Hello and welcome again. Today we'll be discussing which option, the H1B or L1, is better for you. For many professionals and managers, the H1B and L1 visa categories are among the most sought after work visa options. But these two visa categories are vastly different, and it's not always simple trying to figure out which one is right for you or your employees. In this presentation, we'll take a look at some of the key differences between the H1B and L1 visa categories to help you determine which visa is most suitable in your situation. First, I'll give you a quick overview of the H1B and L1 visa categories. The H1B visa allows U.S. employers to employ a foreign national to work in a specialty occupation for a period of up to 6 years. A specialty occupation is an occupation that requires someone with at least a bachelor's degree in a specific field. The L1A visa allows qualified employees of an international company to be transferred to the U.S. in a related company in an executive or managerial capacity. Finally, the L1B visa allows employees of an international company to be transferred to the related company in the U.S. because they have specialized knowledge. In determining the best visa option, the needs of the employer as well as the background of the beneficiary are among the important considerations. To help you determine which is the best option in a given situation, we've highlighted some of the main differences between the H1B and L1 visa categories. Let's first look at the foreign national's education qualifications. For the H1B, the foreign national must have a 4-year bachelor's degree or its equivalent. The equivalency can be based on the foreign degree alone, a combination of the foreign degree and experience, or experience alone, which would need to be at least 12 years. The L1 has no minimum educational requirements. The foreign national's prior work experience. There is no work experience requirement for the H1B visa if the foreign national has the equivalent of a 4-year degree. On the other hand, while the L1 visa doesn't technically have an experience requirement, the foreign national must have worked at a related company abroad for at least 1 year in the 3 years immediately preceding entry into the United States. The U.S. sponsoring employer and foreign entity must also have a qualifying relationship for L1 purposes. This can be a parent-subsidiary relationship, affiliate, or branch office relationship. The proposed position in the U.S. For the H1B, the employer has to show that a bachelor's degree or its equivalent in a specific field is the minimum requirement for entry into the position. For an L1A visa, the position offered in the U.S. must be in a managerial or executive capacity. For the L1B, the proposed position must require a position with specialized knowledge. There's more information about specialized knowledge on our L1B info page on our website. Quota limitations. The H1B has annual numerical quota of 65,000, known as the H1B cap. While the H1B cap only applies to new H1B petitions, there has been a yearly lottery for the H1B because it is such a popular option. There are some positions and employers that may be exempt from this H1B quota. The L1A visa and L1B visa categories have no numerical limit or quota. A required minimum wage. The H1B employee must be paid the greater of the actual wage paid to other similarly situated employees for the specific job or the prevailing wage for the occupation in the area of intended employment. There is no minimum wage requirement for the L1A or L1B visas, however, as long as the employee will be paid the state minimum wage. A labor condition application. For H1B petitions, before filing a petition with USCIS, an employer must submit a labor condition application to the Department of Labor to certify that their offered wage is higher than the prevailing wage or the actual wage. As there is no prevailing wage requirement for the L1, there is also no LCA requirement. Blanket provisions. The blanket L1 provision for certain multinational companies allows them to bypass the USCIS petition process to transfer qualifying employees to the US. These employees can proceed directly to applying for an L1A or L1B visa at the US consulate or embassy because they don't need pre-approval from USCIS. The blanket L provision provides employers with the flexibility to transfer eligible employees to the US quickly and on short notice. Unfortunately, there is no similar blanket provision for H1Bs or their employers. The employer must file an I-129 petition with USCIS on behalf of every individual foreign national proposed to be hired on H1B. Opening a new office in the US. A foreign company that wants to establish an affiliate, subsidiary, parent or branch office in the US can use the new office L1 to send an executive, manager, or specialized knowledge employee to the US with the purpose of setting up a new office. New US companies are also not restricted from hiring employees on the H1B as well. The company, however, must be prepared to show that this individual will have sufficient specialty occupation work and that a proper employer-employee relationship exists between the company and the named employee. The total maximum period of stay for the H1B is 6 years, which can be granted in no more than 3-year increments. The total maximum period of stay for the L1A is 7 years, which is generally granted for up to 3 years initially, with 2 extensions granted in 2-year increments. Finally, the total maximum period of stay for the L1B is 5 years, which is generally granted for up to 3 years initially, with 1 2-year extension. Individuals who come to the United States to open a new office under L1A or L1B will be granted 1 year initially, and then can extend their stays for up to 6 or 4 years in 2-year increments, respectively. Additionally, any time spent outside the US can be recaptured to extend H1B or L1 status. Work authorization for the dependent spouse. The spouse of an L1 employee can obtain L2 status. The spouse of an H1B employee is eligible for H4 status. L2 visa holders can work in the United States, either incidental to status or by waiting to obtain their work authorization from USCIS by filing a Form I-765 and obtaining an EAD. There are no specific restrictions as to where or for whom an L2 spouse can work. Generally, H4 visa holders are not allowed to work in the United States. A small carve-out, however, has been created for H4 spouses whose H1B spouse has an approved Form I-140 and whose visa number is backlogged, or who has received a 1-year extension of their H1B beyond the 6th year under AC 21. Payroll. For an H1B visa, the foreign national must be on the payroll of the US company, and a valid employer-employee relationship must exist between the US employer and the foreign national employee at all times. For those on L1, however, the foreign national can be on the payroll of the US employer and/or the foreign company. Changing employers or portability. H1B portability provisions allow a foreign national in H1B status to begin working for a new employer as soon as that new employer files an H1B petition on his or her behalf. They don't have to wait for an H1B approval from USCIS. There is no similar portability provision for L1 employees. A foreign national in L1 status can only work for a qualifying member of the multinational group that filed the petition. He or she will not be able to work on a new L1 for a company that is not a qualifying member of the multinational group. Path to the green card. Most H1B and L1B visa holders and some L1A visa holders will require a labor certification to be filed on their behalf through the Department of Labor to be eligible for the green card. Some individuals on L1 or H1B may also be able to apply for an expedited green card in the EB1C category. and waive the labor certification process. An employee may be eligible for the expedited green card in the EB1C category if he or she was a manager or an executive before coming to the United States in a qualifying related company and is being sponsored for permanent executive or managerial position in the United States. Also, as mentioned a few moments ago, once the green card process is initiated, only an H1B holder can extend their stay in the US beyond the maximum 6th year if a labor certification or I-140 has been pending for at least 365 days or an approved I-140 is retrogressed. No similar provision is available for L1 visa holders. Employees in L1A status who need to maintain status beyond the 5th year will need to consider changing their status to L1A or H1B. In conclusion, while both the H1B and L1 visa categories are suitable for many professionals, their features and requirements vastly differ. Identifying the right visa category that meets the intended purpose requires a comprehensive review of the circumstances, and doing so will increase your chances of securing an approval. If you have any questions on how to determine the most appropriate visa type for your situation or need help filing for a US work visa, please call 202-787-1944 or send an email to rose.kelly@visapro.com. We'll analyze your scenario and recommend an effective strategy based on our attorney's near 100% success rate. With that, we've come to the end of today's presentation. If you wish to continue to receive updates on these topics and more, subscribe to our newsletter by visiting www.www.visapro.com/visa-newsletter-subscription. Have a great day.